was in a private parking lot, a confidential tip was given to law enforcement about the transportation of a large amount of cocaine by Johnny Coke. Therefore, the law enforcement has probable cause under the Fourth Amendment of the Constitution of America to place a GPS device on Johnny Coke's car, regardless of whether or not he was in a public or private lot, being a Walmart parking lot. Thus, the actions of bringing in a canine unit are justified due to a probable cause. Probable cause is defined in Statute 5.3 as follows. Probable cause is supplied by evidence which would lead a reasonable person to believe that an offense has been or is being committed. The evidence is a confidential tip, which is taken very seriously by law enforcement agencies. Thank you.
So are you saying that the call from the anonymous person was substantial evidence?
Yes.
Or
However, was there any attempt to verify whether the facts regarding the confidential tip were true?
I mean, it's a confidential tip, so it just came from a random person. Like I said, whenever a confidential tip is made, if it's threatening to the betterment of society, it's going to be taken serious, whether it's a terrorist attack or.
Right, but was there any sort of investigation that whether or not there was a large amount of cocaine in his presence, or was it simply, okay, here's a tracking device, let's put it on his car?
The facts state they had a confidential tip.
That's a good question.
Student explanation or no attempt to obtain a warrant?
There's no explanation, it's just the fact that they placed the GPS.
Nothing further? So you see the at 10 minutes.
Thank you, Your Honor. I'd like to state that I agree with the decision of the judges that if this state were to base their decisions off of anonymous tips, the Fourth Amendment right would be trial all the time, violating all kinds of people's rights. Somebody could call in and say, hey, my neighbor's a drug dealer. Okay, well, we'll go search his house then because now we have probable cause. For my opening statement, I'd like to say that the defense is going to try to prove that my client, Coke, is being tried with the GPS, and the cocaine should be suppressed because it's in violation of the Fourth Amendment right. And the GPS was unlawfully put on his car in a privately owned parking lot under Walmart, and that the canine unit should be thrown out, and anything evidence obtained by the canine unit should be thrown out because the canine unit was radioed in as he was entering the jurisdiction of the officers, thus entrapping the client, and the canine unit wouldn't have been present if there wasn't a GPS tracker on the client's car.
Good question. So the client was driving with a suspended license, correct?
Yes, Your Honor.
So who's to say that the claim that it was set up as a bait situation, let's say, is valid, or if they just grab somebody on a different cause?
Basically, Your Honor, the facts state that the officers sat on the interstate and watched him through the GPS, and that they radioed in a canine unit to come and follow him. And that means that the canine unit wouldn't have been present if the GPS had not been on there to get him as they entered their jurisdiction. So therefore, it would have been an interstate cop catching him and seeing that his license had been revoked. And usually in those kinds of situations, the person is confined and then sent home and then trial without a search.
Did the fact state that the GPS provided any information that there was cocaine in the truck?
No, Your Honor. The GPS didn't prove that there was cocaine. The canine unit did, and the canine unit wouldn't have been that. That's the main point of the question.
How does it say the canine unit discovered the cocaine?
The dog sniffed the car, and then the officer with the canine unit proceeded to search the man's car.
He sniffed the car. Can you read that from there?
Yes.
You can take your time.
right here. When the canine officer got out with Coke, he first informed him of the reason of the stop, secured him, and walked the canine around the vehicle. The canine alerted drugs in the vehicle. It was a canine sniff. I don't see it in quotations, but
So if it was a routine stop for suspended license, in your opinion, is there any reason for the dog to even come out of the car?
no, it was completely honest. Canine unit should never have been present. It should have been an interstate or highway patrol car.
Right, let's just assume it wasn't when the canine unit,
Okay.
or when somebody moved. Was there any probable
No.
cause for them to remove the dog as opposed to just having the officer go investigate?
No, usually in that situation, an officer wouldn't remove the dog unless probable cause, but it would have to be more verified probable cause than an officer's call.
Questions?
Did the officer state that he may have thought there was cocaine in the car by the occupants in the cars?
No, you're right.
I have a question. Go ahead. Before the canine unit, you mentioned they didn't have probable cause to take action. What action did they take that they needed probable cause for?
They put the GPS on the defendant's car in a parking lot, privately owned, where the officer had no jurisdiction unless he was parked in a handicap spot, which my client was parked in a valid spot. So therefore, they vandalized his car, which would be another offense.
If you are driving on a suspended license, are you still able to park in a handicap spot?
No, Your Honor, no one, unless you have a handicap license, can park in a handicap spot, but my client was parked in a valid spot.
Question. Do you know of any legal declaration that states that if the substance is illegal, there is no requirement for warrants or proof that for a warrant that if the substance is illegal, can it still be obtained because it is an infringement to society?
No, Your Honor, I don't know the exact code, but I do know that every law states that no matter what evidence is claimed, without a warrant, it's invalid and it always will be thrown out for.
Best of your knowledge, client Mirandized and he was arrested.
The facts do not state, but I would assume that the officer would have.
Further question? And we have 2 minutes for
I'd like to point out on the last page of the case we were given, it reads as this. The state argued that the officer stopped Cook for speeding and driving without a valid license, and therefore the issue of the tracker made no difference. So essentially, that just wiped out the tracker from the case. So what we have is we have a traffic stop. We have a confidential tip that this man was in possession or could be in possession of drugs. When you are arrested, you are allowed to be searched. And I also found a statute that states automobiles. It says an automobile affords a lesser exception of privacy than a house for Fourth Amendment purposes. And that statute going forward. So when they made the traffic stop and they found out that his license was suspension, he's allowed to search. He's allowed to take a drug dog around the car and do a search. The drug dogs smell the drugs from outside of the car, and that also inflicts probable cause for them to go into the car and search him.
Would you say that if this tip hadn't been put out there, the canine unit would have just had the officer come out and do the
GPS was not there. From the facts, it's possible that we're not even there.
It states that he was caught speeding, correct?
Yeah, that is correct.
However, we do not know if from the case file, it was known that he was seen speeding. It was known that he was going 69 in the 45 zone, correct?
Correct.
Do you believe it's possible that this information could have been obtained since the GPS tracks location and speed is measured in time over distance, where you are from one point to another in a set distance, which could both easily be traced through a GPS system?
It says in here, Cope passed the officer who clocked 69 miles.
Okay.
Are you saying that the drug, I'm assuming there was a cop car that pulled him over?
Yes.
And a drug dog unit in another vehicle, correct? So are you saying they just happened to be with each other at the same amount of time?
No.
Because what you said earlier contradicts that statement.
I'm not saying that they were there at the same time. With the use
They just happened to be there at the same
No, they didn't.